All right, if you're on the path to becoming a barrister, you know that mastering the federal court rules is absolutely non-negotiable. So today, we are zeroing in on one of the most fundamental tools in your arsenal, the affidavit. We're going to break down Division 29.1 rule by rule so you have exactly what you need to nail your exams and hit the ground running in practice. We're going to follow the entire life cycle of an affidavit, right from its creation to its ultimate test in court. We'll cover when you can start, how to build it perfectly, what you can and can't say, how to fix mistakes, how to serve it, and finally, what happens when your deponent, that's the person making the statement, has to face the music in cross-examination. Let's jump in. So, first things first, where do we even begin? When can you actually create an affidavit? The starting gun for that is Rule 29.1. Now, Rule 29.01 looks simple, but it's incredibly important. It tells you that an affidavit can be sworn or affirmed before or after a proceeding officially kicks off. What this really means is that it gives you the flexibility to get your evidence locked down early. For your exams, remember this. Rule 29.01 is your ticket to getting a strategic head start. Okay, we've got our starting point. Now, let's build the thing. And for that, we turn to the big one. Rule 29.02. Honestly, you should think of this rule as your formatting Bible. Getting this wrong is such an easy way to lose marks or look sloppy in court, so let's really dial in on the details here. Rule 29.02 is basically a non-negotiable checklist. Subrule 1 says you must use Form 59 and write in the first person. I saw this, I did that. Subrule 3 says every paragraph has to be numbered, and each one should really only deal with a single topic. Then you've got Subrule 6 and 7, which are about the physical pages. You have to number every single page, one after the other. And, this is key, both the deponent and the witness have to sign each page of the affidavit itself. Just the affidavit, not the attachments. Let's talk about those attachments, the annexures and exhibits. The documents you're attaching as evidence. They get identified with the deponent's initials and a number, something like AB-1. But here is the classic exam trap, straight from Rule 29.02, Subrule 10. You can never, ever reuse a number for that deponent. If you used AB-1 in their first affidavit, the next document they annex in a second affidavit has to be a new number, like AB-2. It ensures every piece of evidence from that person has a unique ID for its entire life. Don't forget that one. Okay, so we've nailed the structure, the form, the formatting, but what can you actually put inside the affidavit? The substance of your evidence is all governed by Rule 29.03. Think of Rule 29.03, Subrule 1, as your quality control. The content has to be factual, it has to be relevant, and on the flip side, there's a whole list of things you absolutely must not include. We're talking scandalous, frivolous, or vexatious material. The language can't be slippery or ambiguous either. So what happens if you break the rule? Well, Subrule 2 gives the other side the power to go to the court and ask for that dodgy material to be struck out. It's all about making sure the evidence is clean, fair, and precise. Of course, things don't always go perfectly. This next part is about what you do in special circumstances, like when your deponent has a disability, and also that heart-stopping moment when you realize there's a mistake in an affidavit you've already filed. This is where Rules 29.04, 29.06, and 29.07 come to the rescue. Rule 29.04 is all about ensuring procedural fairness. If your deponent can't read, Subrule 1 says the person taking the affidavit has to certify it was read aloud to them. Same thing for a blind deponent, that's Subrule 2. And if they physically can't sign, Subrule 4 says you need a certificate confirming they still signified that they swore to its contents. These aren't just little technicalities, they are crucial safeguards that protect the integrity of the evidence. Okay, let's talk about that moment of sheer panic. You've worked hard, you've filed the affidavit, and then your eyes catch it. A mistake, an error in the form. What on earth do you do? First things first, breathe. The rules have a safety net for this exact situation. Rule 29.06 says that an affidavit can still be accepted for filing even with an irregularity in its form, so you can get it on the court record. That's your first step. But, and this is a very big but, just because it's filed doesn't mean you can use it in court. That's where Rule 29.07 comes in. It makes it crystal clear that to actually rely on that affidavit with the error, you have to formally ask the court for permission, for leave. So for your exams, remember that two-step dance. Rule 29.06 lets you file it, but Rule 29.07 says you need leave to use it. Right. Your affidavit is error-free, it's filed, it's ready. Now you have to actually put it to work by getting it into the other side's hands. Let's look at the rules for service. Rule 29.05 is beautifully simple. There's no gray area here. If you serve an affidavit, you must also serve copies of every single document that is exhibited or annexed to it. You serve the whole package. No surprises, no holding things back. The other side gets to see exactly what you're relying on. Now, for the timing of that service, there is one magic number that you have to burn into your memory. And that number is 3. Rule 29.08, the 3-day rule. You have to serve your affidavit on every other interested party, at least 3 days before the day you plan on using it in court. 3 days. Rule 29.08. That's one of those hard deadlines that you just have to know cold for the exam. We have arrived at the final stage. The affidavit has been created, perfected, and served. Now it faces its ultimate test, where the written words are put under the microscope of cross-examination. This is all covered in Rule 29.09. Under Rule 29.09, specifically subrules 1 and 2, the other party has a right to send a notice demanding that your deponent show up in court to be cross-examined. This is the process that transforms that stack of paper into living, testable evidence before a judge. So what happens in the nightmare scenario? The hearing day comes, you're ready to go, you want to rely on your affidavit evidence, and your deponent is a no-show. What are the consequences? Well, the default position under Rule 29.09, Subrule 3, is pretty brutal. If your deponent doesn't turn up, the affidavit may not be used. Poof, your evidence is gone. But there is a potential backdoor. You can make an application to the court asking it to use its general power under Rule 1.34 to dispense with the rules. And don't forget, under Subrule 4, if they do show up and get cross-examined, you then have the right to re-examine them. So let's wrap this all up with a classic exam scenario to make sure it sticks. Your deponent doesn't show. The other side is on their feet objecting. The judge turns to you and says, "Counsel, your submission." What do? Well, you stand up, you acknowledge the default rule, Rule 29.09, Subrule 3, but then you immediately pivot and make an application for the court to exercise its discretion under Rule 1.34 to let you use the affidavit anyway. That is how you pull all these rules together.